It's 12 o'clock on Tuesday, February the 28th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, take the roll.
Representatives Campbell, Davis, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Sherrill, Towns, Chairman Doggett. Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin this morning or afternoon? Seeing none, our Sergeant of Arms, Mr. Tyler Muniz, will have our weekly words of wisdom.
Good afternoon, everyone. Sorry for the inconvenience. Today's words of wisdom will be brought to you by the nature boy, Ric Flair. To be the man, you have to beat the man.
Well, thank you all right, members, if you will, let's jump right in. If you'll go with me through the calendar, we'll take care of a few things. Item number one, House Bill 1029 by Representative Littleton will be rolled 1 week. Item number 6, House Bill 1520 by Representative Hardaway is off notice. Item number 11, House Bill 717 by Representative Sparks, rolled 1 week. Item number 12, House Bill 441 by Representative Shaw is off notice. Item number 14, House Bill 253 by Representative Parkinson, roll 1 week. Item number 16, House Bill 1475 by Chairman Halsey is off notice. And item number 17, House Bill 1482 by Chairman Halsey is off notice. Let's go back to item number 2, House Bill 1385 by Chairman Reagan. Second. Mr. Representative Reagan, you are recognized.
Thank you, Mr. Chairman and committee. This is the bill that I had before you that I rolled on the basis of inputs that I got to take it completely out of the code. And then I got emails after that indicated there were some problems with that. So I'm back before you with the bill as it was originally written, and I'm asking for your vote on it. Its purpose, quite straightforwardly, is to clarify TCA 3917-1301 by defining the phrase intent to go armed in order to avoid a constitutional conflict and so that the average citizen can understand it. The impact, straightforwardly, is that citizens will not be accused of wanting to hurt others by accidentally having a weapon in an improper venue or just carrying one, period. I will point out to you in the email that I sent you earlier that we have a court case to deal with. That is to say, the Heller case and the Bruin follow-up case. In the Heller case, the court ruled that there is an individual right to keep and bear arms, and it is assigned to the individual. The majority opinion of that court basically held the following. The Constitution was written to be understood by the voters, and its words and phrases were to be used in their normal, ordinary, as distinguished from technical meaning. Normal meanings can include idiomatic meanings, but excludes secret or technical meanings that would not have been known to the ordinary citizen of the founding generation. I also quoted for you in the email I sent you the Tennessee Constitution, which basically, I'll quote again for the sake of the record, that citizens of this state have the right to keep and bear arms for the common defense, but the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. That phrase, the view to prevent crime, is what this bill is about, is establishing a definition of the intent to go armed as it relates to a view to prevent crime. The bill is straightforward. It's only 4 lines. It defines the intent to go armed as meaning carrying a weapon with premeditation and forethought to commit an infamous crime, and does not include inadvertent or unintentional intrusion to an area which such weapon is not permitted. A straightforward definition which eliminates the conflict that exists currently between the Tennessee Constitution and the U.S. Constitution. With that explanation, I stand ready to answer questions.
Thank you for that explanation. Members, we do have guests here to testify, so without objection, we'll go out of session. We will hear from Elizabeth Stroker, Patrick Powell, Jimmy Music. You will introduce yourself for the record. You'll have 3 minutes for comments, and what we'll do, we'll just go 1, 2, 3, and then we'll have the committee, if they have questions for you, come back and do that. But help yourself.
Elizabeth Stroker, Legislative Director for the Department of Safety. We have some concerns with the bill, not necessarily because of the intent. I think the intent to make things clear is a valid one. However, as I've explained to the sponsor of the bill and some people in this committee, this definition actually is going to do more harm than the good it's actually intended to do. It is going to specifically say that if someone does not have the intent to commit a crime, then they are not carrying with the intent to go armed. That means if we stop someone who's carrying a firearm or any weapon, this definition would allow you to carry any weapon anywhere as long as you do not intend to commit a crime. If we stop them, if they say, hey, I have no intent to shoot somebody or harass somebody or assault somebody, there's nothing we can do. So that's kind of where, again, the intent is valid of what the sponsor is wanting to do, but how it is being executed here actually does a lot more harm for anyone who wants to carry lawfully and anyone who wants to be safe wherever they may be going when someone is carrying any type of weapon. So our request was that either it be amended, and we tried to work on that, and that didn't work. Additionally, the case law has made it pretty clear that intent to go arm is well understood in the court system in Tennessee. It's not something that is problematic or not understood, and so we don't see a need to fix it, especially if fixing it makes it to where it's going to actually make people be able to carry who legally should not be carrying just based on a definition that is drafted badly. So I'll leave it at that and let TBI go after me.
Patrick Powell for TBI. Similar concerns to the Department of Safety. Again, it's not an intent issue. In fact, we were trying to work with Chairman Reagan on an amendment that we thought could resolve the issue. We were worried about inconsistencies in the code, both from our solution and from this bill. The solution, we thought, had fewer inconsistencies. This one would allow, again, as she stated, unless you have the intent to commit arguably a felony, you're not going to be prohibited. The problem is several statutes have prohibitions based on the way they've been written in the past. So, for instance, convicted stalkers are prevented from carrying right now or with intent to go armed. So deletion of that requirement, or I guess the addition that it would have to be to commit a felony, a convicted stalker will be able to carry all the time unless we could somehow prove that they were going to commit a crime. Similar for a DUI second or more, I believe individuals currently are prohibited. That would change based on the way the statutes are drafted. So it's the unintended consequences of the drafting that give us concerns. I think it causes more confusion. And again, we are unaware of any, confusion on the current language surrounding intent to go armed. So this is a solution in search of a problem. Thank you.
Good afternoon. Jimmy Music. I represent the Tennessee Sheriff's Association, the Tennessee Association of Chiefs of Police. Both of those associations of local law enforcement in Tennessee had a lot of the same issues and concerns that you heard from the Department of Safety and TBI, especially in some of these, like the intent to go armed verbiage is in the school setting. So it's illegal and it's an offense to carry in a school with the intent to go armed. And so, if you take that on its face value with this definition, our question was, well, could you carry in a K through 12 school or not? But because you're stuck back to trying to figure out whether that person has premeditated to commit an infamous crime. So I think the argument would be that you probably could, which I don't know if that's the intention or not. It doesn't sound like it. I think it's and we think it's a noble intention to try to accomplish, but I'm not sure that this actually is making it better for because that term is used in so many different code sections.
Thank you. Any questions or comments? Chairman Halsey.
Thank you. I actually like the bill, and I like the intent of trying to straighten it out. We have folks who believe that we are not a true constitutional carry state, and they have real issues with it. Why can't these two things go hand in hand? Why can't the bill stand that you have a constitutional right by the Second Amendment to carry, so the offense is not carrying? The offense then would be if you intend to commit crime, and I understand what you're saying, but then why would not it's already illegal on the books to carry a handgun if you have been convicted of aggravated domestic violence? Why can't those two work together? In other words, Chairman Reagan's bill stands unless you fall into this category of this, and then you can't.
Patrick with TBI again. I think that the concept you can. The problem is in the execution. The verbiage of different statutes is different depending on the prohibition. There are times where possession of a firearm is prohibited. There are other times where going armed is prohibited. So situations like we've brought up, where whether it be some of the school language, whether it be parks, whether it be a mental defective, whether it be someone convicted of stalking, there are different portions of the code that have been tied to the intent to go armed. So again, the concept is a different animal altogether. It's the execution and the language that we have to go by what the language says, not the concept. So again, with the language being what it is, we have issues.
Any follow-up, Chairman? Any other questions? Oh, yes, sorry, Representative Johnson.
Thank you, Mr. Chairman. Yeah, and we do know from the Heller decision that there are protections that are allowed when it comes to the Second Amendment, and that has been established by the Supreme Court. But I really appreciate your testimony, because on my reading of this, it was, I see the intent to make the definition for that, for intent to go armed. But what I was seeing was that, only an infamous crime, but what about a regular crime? And just the problems with the language are, the reason I can't support this legislation, because I think it leaves too much to chance. And I think that it might cause a lot of problems. So thank you for verifying what I was thinking.
Any other questions? Thank you all very much. Next on my list is Carol Frazier. If you will introduce yourself for the record, you'll have 3 minutes for testimony.
Yes, my name is Carol Buckley Frazier, and I'm a resident of Davidson County. I'm a volunteer with Moms Demand Action for Gun Sense in America, and I am incredibly concerned.
Ms. Frazier, you want to make sure that your microphone is on, please.
Sorry, how do I do that? Hello?
There you go.
Do I need to repeat? Can my 3 minutes start now?
Yes, please. Please
Thank
repeat.
you. My name is Carol Buckley Frazier, and I'm a resident of Davidson County. I'm a volunteer of Moms Demand Action for Gun Sense in America. I am very concerned about this bill, which will make dramatic changes to current law regarding carrying in public. Today, Tennessee law prohibits carrying a firearm with the intent to go armed unless a person is 21 years of age, carrying a handgun, and can lawfully possess that gun. This flips years of Tennessee law around and says that unless a person carries a gun for the purpose of committing a felony, they are not carrying unlawfully. Passage of this bill means an 18-year-old can carry a loaded handgun or long gun openly or concealed at a playground. Parks and playgrounds should be safe. This bill actually undermines a parent's right to keep their children protected. Passage of this bill means that someone as young as 18 can carry a loaded gun anywhere they like. Sadly, research shows that people in this group are 3 times more likely to commit gun homicides than people 21 and over. We've already seen a dramatic increase in gun violence in this state, and this bill will make things worse. Imagine a sheriff or a police officer in this world where gun carry is normalized and you are powerless to do anything until it is too late. How can they tell the difference between someone who has just forgotten to secure their gun in a car but has no plan to hurt someone and someone who is at the playground to shoot his kids because he's angry at his ex-wife? Until shots are fired, both would be legally carrying, and law enforcement's hands are tied until the shooting starts. Who are the winners in this world? That would be the money people. The gun lobby puts the industry's bottom line above the safety of American communities. Dangerous gun laws like this are critical to their business model because they put more weapons in more hands with less responsibility. Instead of standing up to the industry, it seems that Tennessee lawmakers are bowing to it, trying to score political points. And the constituents and residents of Tennessee are the ones who are left dealing with trauma and grief. We are the losers. We are the losers in this equation, dying in shootings or surviving for years with shattered minds and bodies, kids shot in drive-bys, or finding an unsecured gun laying around and unintentionally firing it, kids who use their parents' guns to end their lives. Welcome to Tennessee, where gun carry is easy and stress-free. But we're free, you say. Yes, free to die before our time. This is not freedom. I would suggest that if you stand in the cause of freedom,
Ms.
you
Frazier,
will
thank you.
oppose
Your
this
time is up.
bill. Thank you.
Thank you for your comments. Members, do we have any questions or comments? Representative Gillespie.
Thank you so much, Mr. Chairman. Just a quick question. I live in West Tennessee and Memphis. We have a crime epidemic already. This year, I think we're, not even into the done with the second month, and there have already been, I think, over 1,000 vehicles broken into for guns being stolen. Those guns are then going into the hands of bad actors, people a lot of times that have no record whatsoever, so they're perfectly legal to carry those guns until they shoot someone. So my question is this: in your opinion of being on the ground roots, is this something that would make us less safe?
I think lowering the age to 18, and as I have said, this is a group that tends to commit most of the homicides that we see. We also know that this is a group that is experiencing incredible mental health crisis. Yes, I think it would make it worse.
Thank you. Representative Hardaway.
Thank you, Chairman. Good afternoon, ma'am, and thank you for the work you do.
Thank you.
Are you aware of the science that speaks to the brain development of 25-year-olds and under, and the lack of maturity until you're 25-ish?
Yes, I am. I have 3 adult children in their 30s, and I can definitely attest to that.
Okay. And
I'm also I work in the health and wellness field, so yes, I'm aware of that.
when you combine that with the post-pandemic emotional, psychological, social deficiencies that came out of the pandemic, our children on every age level didn't have a chance to have that emotional development, that psychological development, social interactions, to where they could become, for lack of a better term, normal. Mm-hmm. How do you see that jiving with these same young folk having a deadly weapon in their hands?
Well, we can see a rise in suicides during COVID and afterwards as well, and that grew significantly. And actually, 50% of gun deaths are suicides. So if we're giving 18-year-olds the ability, without the responsibility, by the way, the ability to carry in public, and they feel less than, or they are having a mental crisis, and they are using that gun to prove a point, to respond to bullying, whatever it is, I think they're very correlated, absolutely.
If I may interrupt, I'm sorry. This bill does nothing to address age. So let's, if we can, let's focus our comments and questions on the actual language of the bill.
Mr. Chairman, could you be clearer?
Yeah, sure. The language of this bill does not address age. It's been referenced 21 to 18. That is nowhere in the language of the proposed legislation that we are considering today.
Mr. Chairman, then I need to go to legal at some point and find out whether those under 25, and that's what I'm referencing now, those under 25, those who don't have the full brain development to control impulsive behavior. So unless this bill did address age and exempted everyone 25 and under, then that's where my concern is.
Would you like to ask legal?
Yes, sir.
Michelle Fogarty, Legal Services. The bill as written simply defines the phrase intent to go armed. It does not do anything, there's no other language in the bill. It just defines that phrase as it is used throughout the code. So it doesn't change, it doesn't make any changes in regard to current law about age. It just defines the phrase intent to go armed.
Yes, sir.
Thank you, Chairman. And currently, intent to go armed would allow, at what age would you be allowed to go armed?
Under 3917-1307G, you have to be 21. Or 18 if you're in the military, honorably discharged from the military. And that applies to handguns.
And long guns? What are the restrictions on long guns?
It's my understanding that you just have to be 18 to purchase a long gun. That's current law. And that's also consistent with federal law. It is an offense under 1307A currently to carry with the intent to go armed a weapon. It is a defense if you are carrying it for the purposes of hunting, trapping, fishing, protection of livestock. There's a whole list of exceptions to our defenses to that.
All right, Mr. Chairman, I'm ready to go back to our witness.
Okay, proceed.
Ma'am, having heard that explanation, my mindset is still the same. How does it impact your mindset, and how this bill will enable young folks and others? It's not just young people who cannot control their impulses. It's not just young people who lack that discipline, who are irresponsible, but may otherwise be qualified to carry a weapon. How does that explanation impact your thinking?
Well, when we talk about with the intent to commit a crime, I think we're still talking about the fact that we are giving our law enforcement just an enormous task to figure out whether people have an intent to carry out a crime, and that's why they're carrying their guns, or if they are there just carrying their guns. I think that I do know that there is a bill to lower the age to 18 as a constitutional right. I think we have to remember that even Scalia, in the Heller opinion, said that rights are governed by guardrails and regulations, and that we need to have regulations. Well regulated are the terms. So I don't see anything different in what I would feel or what I would say about this bill.
Thank you, Chairman. Thank you, ma'am.
Yes, thank you. Chairman Halsey.
Thank you, Mr. Chairman. I disagree with a whole lot of what you said. I'm glad you're here, and I appreciate the fact you are. You have some folks in your organization up in my district, and I've met with them, and they're very reasonable people and good folks, and they're very passionate about what they do. I think one of the things that you're overlooking is the chairman's bill is defining what it means to go armed. Mm-hmm. We've wrestled with that for a long time. 36 years in the police department I was, and of course there were loopholes in all of that because it depended on the answer. If I stopped a car in the middle of the night and I see the butt of a gun sticking out from under the seat and I say, "Why are you carrying a gun?" If he says to me, "I'm taking it down here to a guy to show it to me, I think he's going to buy it," or "I'm taking it to my brother-in-law to keep it for me because I'm going on vacation," any answer that he gives me gives him a right to carry that gun wherever he's going unless he says it's to protect myself. Mm-hmm. Then he's breached the law. This representative is trying to fix that, and I think it's an admirable thing to fix. But the other side of it is, too, you have a right by the Second Amendment. And the reason it's there is it's because it's for lawful people. Lawful people have a right to protect themselves. I was never afraid of lawful people carrying a lot of guns. Mm-hmm. It's lawless people that are the problem. So if you take a 17-year-old Memphis who broke into a car and stole a gun, he's a lawless person, which means he will not abide by any law. Mm-hmm. Lawful people abide by the law. So in that regard, I think that's why there's a Second Amendment. It's for lawful people to be able to protect themselves. And that's the whole issue. And I think the representative's trying to straighten out the verbiage so we can get it right. I do appreciate you being here.
Thank you.
Thank you. Any other questions from the members? Representative Hardaway?
Thank you, Mr. Chairman. I'll be brief, but this isn't a bill about Memphis, and I hope not. And there are unlawful actions involving firearms. I know Chairman Halsey didn't mean anything by it, but I want to make sure that the rest of my colleagues and those who are listening over the internet, that Memphis is not held out as the Wild Wild West of Tennessee. Every time I go on the internet, Mr. Chairman, I can look at East Tennessee, I can look at Knoxville, Chattanooga, Tri-Cities. I can look at Middle Tennessee with Davidson County and Nashville, and I will see a shooting. I will see an act of violence every day that I read the news reports. So I would ask that my colleagues not single out Memphis. We don't do anything differently in terms of how we live and raise our children than you do. The problem is that we have too many gun laws that are coming too fast. Law enforcement cannot get their arms around it in terms of how to protect themselves and thus protect the public. So, Mr. Chairman, I just had to get that out. Thank you.
Thank you. Anyone else? Seeing none, thank you for your time being here with us today. We're going to go back into session. Leader Lambert.
Thank you, Mr. Chairman, and I listened carefully to the witnesses that testified, and I will say this. If we do not preserve our individual liberties, and they are not for sale, ma'am, with all due respect, if we do not preserve our individual liberties, then we have nothing left in this country to fight for. So this bill is an attempt to at least try to make sure that there is an understanding between intent to go armed and simply possessing or carrying a firearm, and to make sure that those that are allowed and legally able to carry are not in any way harassed by their government, in any way molested by their government, in any way their rights infringed upon by their government. I have a simple question, because I think there may be something that just in the drafting of this is a problem. But the intent of it, I support 100%, just as my chairman and others have said. So, Mr. Chairman, if we could go to legal for a quick question.
All right, without objection, we'll go out of session. Hear from Legal Services.
Mr. Chairman.
Leader Lambert.
Thank you, Mr. Chairman. Here's my question. If we were to change this as drafted, I know there are lots of folks that within the code are prohibited from carrying a firearm. They are prohibited from, possessing a firearm with intent to go armed. They cannot possess it. Those that are illegal immigrants, those that have been involuntarily committed to a mental institution, those that are under 18. I mean, there are a wide variety of individuals that have lost their right to bear arms. How would this bill as drafted affect those categories of individuals?
Michelle Fogarty, Legal Services. So currently under 3917-1307, subsection H, a person commits an offense who carries with the intent to go armed a firearm, and they have been convicted of stalking, DUI once in the past 5 years or twice in the past 10 years, or has been adjudicated as a mental defective, judicially committed to or hospitalized in a mental institution, or had a court-appointed conservator, or they are otherwise prohibited from possessing a firearm under 18 U.S.C. 922G. So if this bill passes as written, then that group of people will only be committing an offense if it can be shown that they were carrying that firearm with the premeditation and forethought to commit a felony. And persons who are currently prohibited from possessing a firearm under 18 U.S.C. 922G, that would be persons who are under a order of protection, persons who have renounced their U.S. citizenship, persons who have been dishonorably discharged from the military service, persons who are illegal immigrants. And also the phrase intent to go armed is found in 1309B1, which makes it an offense for a person to possess or carry, whether openly or concealed with the intent to go armed, any firearm on the property of a school. That's a Class E felony. If this bill passes as written, that would be a Class E felony only if it could be proven that the person was carrying with the intent premeditation and forethought to commit a felony. It is still an offense. It would still be an offense under subsection C to possess a firearm on school property. However, subsection E of that statute also lists a group of persons that the offense in B does not apply to. That would be civil officers, officers of the militia, persons in the military, persons who possess a handgun carry permit, and a whole list of people. So those people could carry a loaded firearm on school property even with the intent to commit a felony and would not be committing an offense because they're listed as, it doesn't say exception, but it says the offense in B does not apply to them. Same thing under 3917-1311 in public parks, where it says it is an offense to possess or carry with the intent to go armed. That would no longer be an offense unless it could be shown that the person was carrying with the premeditation and forethought to commit a felony. And also under subsection B, it says that the offense in A does not apply to the following persons: civil officers, soldiers in the militia, persons employed in the military, law enforcement, private police, reserve officers, persons possessing a handgun carry permit. So if it doesn't apply, then they would not be committing an offense if they were carrying even with the premeditation and forethought to commit a felony.
Thank you. Representative Gillespie, you have a question for legal?
Thank you, Mr. Chairman. Thank you, Michelle. Just curious, does this change if you're consuming alcohol or drugs? Is there any section of the code that says this intent to go armed in reference to drinking or, such things such as that?
that phrase is not in the statute. I don't believe that deals with carrying while consuming alcohol. So no.
Any other questions for legal? Representative Hardaway.
Thank you, Chairman. I want to make sure that I'm clear. From what you're stating, there's a couple of classes of individuals who currently would be violating the law with intent to go armed, but with this new proposed legislation would no longer be illegal in that sense. Is that correct?
That is correct.
All right, thank you. And Mr. Chairman, just want to take a little personal privilege. Two of the best county commissioners in the world, Charlie Caswell and Brittany Thornton out of Memphis, Shelby County. Brittany, for instance, is my personal county commissioner, and Charlie Caswell is my spiritual county commissioner. But Mr. Chairman, I just want to make sure we recognize him.
Well, yes, sir. Thank you and welcome. All right, members, no other questions for legal. We'll go back into session. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And Chairman, I know you obviously will follow along with what legal said. I've talked to you about this bill. I know that your intention is not to allow for illegal immigrants or those that have been mentally committed or anyone to carry, or at least that's my impression. It sounds just to me that there's probably a little more work here just to be done on drafting. How would you like to proceed? Because I'm definitely concerned on just kind of what I heard today as far as just the drafting of it.
Thank you, Mr. Chairman. And before I address your question, let me clarify a few things that were put forward. Convicted felons are still prohibited from carrying firearms, which is not going to change under this law. Non-felonious stalkers are also prohibited under the federal code that legal cited, that was USC 922G. Schools and other property is not affected. Property rights are not changed by this law. If someone posts their property that no firearms are allowed, this law does not change that. So those things that are in existence now remain unchanged by this law. The obvious problem we have here is if I were to ask legal right now, and I won't because we'd have to go out of session, to define the words intent to go armed, what would be the definition? And then if I were to ask, is that definition in conflict with what was put forward in Heller and Bruin, I think the answer would come back yes. So to directly to your question, we have a problem that needs to be resolved. I indicated the last time I was in front of you that I was willing to work with people to change it, in fact, to completely eliminate the phrase. And then I got some emails after I left this committee that indicated there were other situations that made that change untenable. So in the spirit of willingness, I am certainly willing to accept additional changes to eliminate the conflict that is currently in existence between our state constitution, where we have a phrase that is undefined, that puts us in conflict with the Second Amendment. And by the way, the 14th Amendment makes that applicable to us. So from that standpoint, we have a problem. Consequently, to the leader's question there, I would ask to roll this for 2 weeks, pending changes brought to me that are not defeating the purpose of this. Mr. Chairman?
Thank you. Well, without objection, we'll roll House Bill 1385, 2 weeks. Members, we're going out of order here. We're going to take up item number 8, House Joint Resolution 94, Representative Hazelwood. There is an amendment, Code 4137. Do you wish to proceed with that amendment?
I do.
You're recognized on the amendment.
Thank you, Mr. Chairman, and the amendment does make the bill. So,
Question's been called. Any objections? Seeing none, we're now voting to adopt amendment code or add amendment code 4137 on the House Joint Resolution 94. Those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're now on House Joint Resolution 94. As amended, you're recognized.
Thank you, Mr. Chairman, and thank you, committee. I'm really glad to be in front of you today talking about Marcy's Law. The conversation has been going on for a while, as we all know, but I feel that we're in a great place, and I want to thank everybody who's had involvement in getting us there, and I'll speak more specifically about this in a minute. But Marcy's Law, for those of you who've not have been involved in the conversation before or who have forgotten, it's will give Tennessee crime victims meaningful and enforceable, and I think that's a key word, enforceable constitutional rights and protections. The accused and the convicted have constitutional protections, and that's as it should be. And I'm proud of what we have done in Tennessee statutorily to make sure that we're trying to take care of victims' rights. But statutory rights versus constitutional rights are two very different things. And Marcy's Law will simply move the victims' rights to the constitutional level so that they're on equal par with the defendants and convicted felons' rights. So Marcy's Law, as I said, will give victims meaningful and enforceable rights to participate in the judicial system. What does that mean? It means they will have notice. If their crime is going to be dealt with in any part of the judicial system, they'll know that that's taking place and they can choose to be present. They will be able to be present. They will be able to be heard if they choose to, if they request to do so. And most importantly, their voice will be recognized by the court. No rapist, no criminal should have more rights than the victim. And Marcy's Law simply will ensure that that wouldn't happen. It will expand the protection of victims in juvenile crimes as well. If you've been violently attacked, you don't really care if the person is 21 or 14 or 16, or the age does not matter. So you want to know if that attacker is being released, whatever their age group. Marcy's Law will strengthen Tennessee's constitutional protection for crime victims. And I know there are people who've said, why do we need this? We already have a Crime Victims' Bill of Rights in the Tennessee Constitution. But currently, victims have found the rights in the Tennessee State Constitution to be unenforceable. Existing Tennessee law fails to provide victims of crime with legal standing to seek redress in a court of law. This will just change that dynamic. It will, again, the whole purpose of Marcy's Law is to make sure that we treat our victims as well as we treat those who are defending or who are convicted or accused of crime. Tennessee's recognized the importance of having the rights of crime victims protected. I think for those of you who believe in polls, it polls really well. People are really think that that's an important thing to do, as I think we all do here in this legislative body. And I want to give a shout out to the chiefs of police and to the Tennessee sheriffs who voted to endorse this legislation. I appreciate them. I appreciate the work that's been done to get to where we are now. As I said, the amendment reflects a lot of back and forth, a lot of dialogue, and a lot of work by a lot of interested parties. And with that, Mr. Chairman, I would just ask that this committee would endorse Marcy's Law and move it to the next step on a fairly long road to constitutional amendment vote.
Well, thank you very much. Members, do we have any? Representative Johnson.
Yes, I'm one of those people who was a victim of a crime and was told after sentencing that I would be let know when the perpetrator was left prison. And I never got informed. And so I like to see, I mean, I would have liked to have known, you know. I'd like to know what that person looks like now. So just to be aware. And so I just appreciate this because I think it's important that victims do get that notice and that to feel a little bit of safety at least when this comes down the pike, as it will.
Well, I think, fortunately, most of us have never been involved in the legal system. If so, only peripherally with our speeding ticket or some other situation like that. So no one really knows what to expect if they become a crime victim. And Marcy's Law just makes sure that we walk alongside the victim, just like we have people who are walking alongside those who are accused, to make sure that they are can be a part of the process and at most be aware of the process and what's going on with their accused.
Yeah, absolutely. Me and the other person who we showed up at court every time, had to take a day off work to show up at court. There was no way I was going to let that go. And they did a great job of taking us in advance and letting us know what our rights were and what they could do. But there was just no follow through, unfortunately, on that. And so it's a little bit unnerving knowing that person is out there. And so this is incredibly helpful, and I appreciate it. And I certainly believe that the perpetrator of a crime should have no more rights than the victim.
Representative Gillespie.
Thank you, Mr. Chairman. Thank you, Representative Hazelwood. I really appreciate it. I think I talk a lot about the criminal actors and some of the problems that we have going on in the state. And, I try to address that in a various amount of ways, but I think the victims of the crime a lot of times aren't represented. And taking this next step, I think, is extremely important and fair. And I just wanted to commend you. I know this has been a long process, and getting the support of some of the people that you already named, I think, is also crucial. But I just wanted to thank you for looking after the people that sometimes have no voice, and a lot of times they don't have a voice. So thank you.
Representative Hardaway.
Thank you, Chairman, and thank you, Chair Lady. As you know, I'm gung-ho on this one. I was with you last session, and I'm with you this session. You were specific about having the right of notice of the release of the offender, alleged offender, I guess, to be honest. But there are 13 that are listed. Can you just give a brief description of those 13?
I can. Number one is the right to be treated with fairness. I think that is the underlying principle of Marcy's Law, to make sure that we are as fair to the victims as we are to those who have been accused or convicted of crime. The right upon request to have reasonable notice of public criminal proceedings, including juvenile delinquency ones that are public. The right to be present at those criminal proceedings. The right upon request to be heard at any proceeding that involves release or plea or sentencing, disposition, parole, as well as any public proceeding when relevant during which a right of the victim is implicated. The right to be heard and informed of all parole procedures, to participate in that parole process, to have an opportunity to testify, to provide information to the parole authority that can be considered when they're making their decision. And this is an important one as well, the right to be free from harassment, intimidation, and abuse through the criminal justice system, including reasonable protection so that the victim doesn't become a victim again from people who are harassing them about not testifying. The right upon request of reasonable notice of any release. To the other representative's point, it's important for you to know if that person is going to be back out on the street again so that you can be a little bit more careful. The right to full and timely restitution from the offender, recognizing that that may be extremely difficult if the offender is sentenced to a long jail term. Its restitution might be difficult, but you have that right. The right to be informed of the minimum sentence the offender will serve in custody and the scheduled release date. The right to have the safety of the victim and the victim's family and the general public considered before any parole or other post-judgment release. The right upon request to confer with the prosecution, to have your 2 cents heard, and the right to be fully informed of all rights afforded to the crime victim, so that everybody is clear about the rights on both sides of this equation. I hope that answers your question.
It did, and thank you, because what you've listed is just a blueprint for justice for victims. Thank you. Thank you, Mr. Chairman.
Yes, sir, thank you. Representative Moody.
Thank you, Mr. Chairman. And Chair Lady Hazelwood, I congratulate you on your tenacity through this process. I remember last term, that last session, the effort that was put forward, and whether it's as the testimony here of actual victim of a violent crime or someone that we all know back home that has been through that process. Thank you. And I'm proud to stand with you again and see this through. So thank you for bringing it back.
And I thank you for your support, past and present.
Thank you. Any other questions for our sponsor? Previous question has been called. Any objections? Seeing none, we're now voting to send House Joint Resolution 94 to full criminal as amended. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move on. Thank you so much. Let's go back in the calendar to item number 3, House Bill 39 by Representative Chisholm. You are recognized, Representative.
Thank you, Mr. Chairman and committee. I have brought to you all what I call the New Deal of bills. Thank you, Mr. Chairman, committee, committee members. The bill before you today deals with the decriminalization of marijuana. The bill makes moves to make personal possession of 1 ounce or less of marijuana simply a civil penalty, on par with simple traffic violations. So, in the United States, 60,000 people are behind bars for marijuana offenses at a cost to taxpayers of $1.2 billion a year. Taxpayers annually spend between $7.5 and $10 billion a year arresting, prosecuting individuals for marijuana violations. Almost 90% of those are marijuana only. Here in Tennessee, it will save the state $15 million in prosecutions, incarceration, and court costs annually. So that's every year. This money could be used to redirect to law enforcement for better technology, for better training, to combat our more dangerous crimes. And this could free up our existing police resources to deal with more serious crimes, as stated earlier. The Journal of Public Health reports that citizens who live in states under decriminalizations do not consume marijuana at a higher rate than those that live in regions that possesses a criminal offense for marijuana. Of course, there are disparity studies that show that individuals of color are arrested at more than 3 times the rate of others, even though the consumption rate is about the same. So there are about 41 states that have already passed some kind of legalization or medical program. All but 2 of our neighboring states have already passed some type of medical or decriminalization program. So that means marijuana is available, but people are going outside of our state and bringing it back. So it also puts our state in a position where we need to regulate. And it also puts our law enforcement in a position where 27% of our property crimes are solved, while 35% of our rape kits are actually solved. And polling shows that 70% of Tennesseans do want some kind of a decriminalization. So this could free the hands up of our law enforcement and save our taxpayers millions of dollars. Now, seeing the posture of this legislation in the Senate, I am going to take this bill off notice so we can have more robust conversations about this. And I also ask that when we bring it up again, that we get you all to sign on to it as well.
All right, thank you for that. I made a mistake earlier. It's actually House Bill 309. 309, I think I called it something different, but without objection, 309 is off notice.
Thank you, Chairman and committee.
Item number 4, House Bill 831 by Leader Lambert.
Thank you, Mr. Chairman, members of the committee. I didn't begin this year intending to clean up a lot of expungement issues, but this is another one of those that came up because of a case that out of McNairy County, if I remember correctly, from last year, where if the TBI receives an expungement order from a judge, whether it's legal or illegal, whether it matches the statute we passed or not, they are required to process it. And nobody's checking with the TBI to see whether or not these individuals are actually eligible for an expungement. So that's what this bill does. It allows for a certification for any type of expungement, just as we do before someone gets pretrial or judicial diversion.
Thank you for that explanation. Any questions, comments for the sponsor? Seeing none, we're now voting to send House Bill 831 on the full criminal. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. We move on to full criminal.
Thank you, Mr. Chairman, members of the committee.
Item number 5, House Bill 688 by Representative Hardaway. Motion. You're recognized.
Mr. Chairman, I've got another amendment I'm working on that, so I'd like to take it off notice.
Okay. Without objection, House Bill 688 is off notice. Item number 7, House Bill 289 by Representative Russell.
Motion.
Second, you're recognized.
Thank you, Mr. Chairman and committee. House Bill 289 will allow a jury to determine whether a defendant's sentence of death must be expedited. A defendant's sentence may be expedited if the jury finds that the offense involved the death of 3 or more victims whom the defendant killed using 1 or more deadly weapons, or the defendant committed the offense by using 1 or more deadly weapons on the grounds of a public or private elementary, secondary, or post-secondary school, or the defendant committed the offense by killing a first responder who was acting in the course of the first responder's employment at the time of the offense, and the evidence presented at the trial proving the defendant's guilt was incontestable. The sentence must be carried out within 30 business days of the conclusion of any appeal and the exhaustion of all available methods of post-conviction relief. If the Tennessee Department of Corrections is unable to carry out a sentence of death by lethal injection, the electric chair shall be used. Mr. Chairman, I renew my motion.
Thank you for that. Any questions for the sponsor? Representative Johnson.
Thank you, Mr. Chair. So did you say that if there can be more appeals, you're not allowing like one appeal, but there can be multiple appeals?
So this is at the conclusion of any appeal and the exhaustion of all available methods of post-conviction relief.
Well, we know that many times people have been found innocent years later or that type of thing. So are we not concerned at all that we might be forcing something that someone might not be guilty?
Absolutely, and that's one thing that we don't want to do is send somebody to death that might be innocent. So I made sure I put in here it's incontestable evidence. It has to be like DNA or on video.
And then if the drugs aren't available, you're talking again about using the electric chair, which has been deemed cruel and unusual punishment.
Well, I don't know that it's been deemed cruel in
3 courts.
Well, let's not cut off each other now. We're not in a continuing debate here. Go ahead.
I don't know about that, but I'd say the victim's family probably would consider it acceptable punishment.
And I do, I certainly understand that, but I just don't see the impetus for making it that quick and resorting to something that I'm not really sure I would hope that this country doesn't want to do again, just for expediency. And as long as that person is off the streets and there's no chance of anything different, I don't see what waiting might do. But thank you.
Thank you.
Chairman Holsey.
Thank you. Chairman, I like the bill. We got into discussion about what is uncontestable, what the word actually means, and is the wording an issue that's going to negate the bill? And I don't have the answer for that. If legal wants to chime in there.
All right, without objection, we'll go out of session. Hear from Legal Services. Representative Chairman Holsey, you want to ask the question of legal?
Can you tell us if the word uncontestable, and I'm not trying to get down in the weeds, but will cause problems in defense of this bill down the road if we pass it?
The term is not defined in this bill. In order for a person to be found guilty, the jury already has to find beyond a reasonable doubt that they're guilty of the offense. So I'm not sure where incontestable lies within that. It's not defined. So it seems like the jury would either have to find, since the jury's already found that the defendant's guilty beyond a reasonable doubt, that they might equate that to mean incontestable. It's possible, or they could hold that to a higher standard. I don't know, since it's not defined. And already the state has the highest burden of proving beyond a reasonable doubt that the defendant's guilty. So it's asking them to review the evidence again when they've already found that the defendant was guilty beyond a reasonable doubt.
Thank you, Chairman. Do you mind, sponsor, if you got a comment about that?
Representative Russell.
Can I comment while we're out of session? Or?
Absolutely.
Okay, so in under section 1, number 2A, it talks about the incontestable evidence may include but not limited to video evidence depicting the defendants committing the offense or the DNA evidence linking the defendant to the offense. So it's defined in the bill.
It's giving examples of what may be incontestable evidence. It's not defining the term.
I disagree. It says what it is right there. Chairman, it says may include. That's what it says, may include.
All right. Do we have any other questions for legal? If not, we'll go back into session. And Chairman Holsey, you're recognized.
No, I'm through.
You're through. Okay. Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 289 on the full criminal. Those in favor say aye. Aye. Those opposed, the ayes prevail. If you wish to be recorded as a no, please see the clerk. Members, I'm going to put myself out of order here. I've got a constituent here with us, Mr. Jason Shelton from Loretta Telecom down there in my district. So welcome. Good to see you. Thanks for coming up. He was peeking through the window on us, so I made him come in. Members, let's go to item number 13, House Bill 577 by Representative Parkinson. You are recognized.
Thank you, Mr. Chair and committee. Let me just identify a problem that came up last year. A gunshot victim was driven to the hospital in my district in a personally owned vehicle. Once he arrived, the actual shooters drove up to the hospital behind him and began shooting on the hospital premises. Of course, this situation created safety concerns for the hospital staff to the point that the leadership felt it was important to ask for legislative relief. This bill creates an enhancement for the crimes of aggravated assault and attempted first-degree murder on the grounds of a healthcare facility. Healthcare facility is defined as a hospital in the legislation. With that, Mr. Chair and committee, I move passage.
Thank you. Any questions for the sponsor? Representative Gillespie.
Thank you, Mr. Chairman. To the sponsor, thank you so much. Was this the Methodist North situation? Okay. Yeah, so completely support it. That was what kind of happened there was the entire hospital was closed for a little bit of time because of the result of this, which I'm sure people were having to be transferred to other area hospitals, which obviously is never a good situation. But thank you for bringing this, and I appreciate it.
Thank you, Chairman.
Thank you. Any other questions? I do have a question. This is not just an enhancement on healthcare workers or staff. This is any person who is on the grounds of
Yes, sir.
a hospital.
Yes, sir.
Very good. We are moving in the right direction per Chairman Halsey. Any other questions? Seeing none, we're going to vote now to send House Bill 577 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on.
Thank you, Mr. Chairman, and thank you, committee.
All right, let's go back a few items here. Item number 9, House Bill 752. Motion. Representative Littleton. You are recognized.
Thank you, Mr. Chairman and committee.
You had it. You're good.
Oh, okay. Thank you. This bill creates a Class C misdemeanor punishable by fine only. For the first time, a foster parent from a kinship placement knowingly allows a child in their care to visit with the child's parent if there is a known current court order prohibiting the child's parent from visiting the child, and increases the violation to a Class B misdemeanor for every subsequent occurrence. So we're seeing that there's a no contact in there in a kinship home, and then the parent comes in and is with the child, and nothing is happening. So,
Well, thank you for that explanation. Any questions for the sponsor? Chairman Halsey.
I just have one. Does that happen very often? I mean, really? I mean, even though foster parents know that's a no-no, it still happens.
it's normally kinship that does it.
Okay.
Thank
you.
Representative Johnson.
Thank you, Mr. Chairman. So I'm curious, is there any consequence as far as from DCS or whoever their custody is through of perhaps losing that custody if they do this? Because I've heard of it as well. And so I was curious if there was anything on the DCS side of it that they might lose custody based on allowing parents to see when they're not supposed to.
I'm not aware of that.
Okay, thanks.
Thank you. Any other questions? Representative Hardaway.
Thank you, Mr. Chairman, and good afternoon, Chair Lady. I just have a fundamental disagreement with creating a criminal act in what, in my mind, should be a civil dispute. So I can't support the bill, though I support the intentions. I just see it as as violating the court order or contempt and letting the judge take it from there. But I do applaud your intentions. Thank you, ma'am.
Any other questions? Representative Moody.
Thank you, Mr. Chairman. It's not really a question. I thank you, Chair Lady Littleton. I know how deeply you care about this issue, and I have seen the books you bring in from Foster Care Review and on it goes. You know a lot of stuff that I don't know, and I'm afraid I couldn't handle. And so I thank you for bringing this bill before us to make a dent in some things. So thank you.
Any other questions? I will ask of you, Representative, is there a specific reason why these children would be placed in foster care, and a specific reason why there would be a no contact order from their actual parents in this?
It's normally abuse.
Right. So there is a reason why
It is abuse.
they are not in the home with their actual parents. And when their parents come in, apparently now, as the law currently sits, there's nothing that prevents them from, or no retribution for them coming over and visiting with their actual children.
They don't always just visit. Sometimes the parents, the kinship lets them take the children with them.
Okay.
And then it becomes even worse situation.
Exactly. So it's a very dangerous situation for the children. Yes. Thank
No
you.
one wants to take the children.
Right.
We all want them to be at home and loved, but they're not.
Right. And it's unfortunate. Thank you for bringing this. Any other questions? Seeing none, we're now going to vote to send House Bill 752 on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. If you wish to be recorded as a no, please see the clerk. Item number 10, House Bill 554 by Representative Littleton. You are recognized. There's an amendment code 4522. Do you wish to proceed with that amendment?
Please.
All right. You are recognized on the amendment.
Thank you, Mr. Chairman. This requires each district attorneys general to designate one assistant district attorney general currently employed with the judicial district as to lead the prosecutor in cases involving committed crimes against children. And I don't think that's what the amendment says, that when they have someone that can do it, it's permissive. And it also requires some training to be at the conference of the district attorney's conference provided by the TBI.
Does the amendment make the bill?
It does.
Okay. Question's been called on the amendment. Any objections? Seeing none, we're now voting to add amendment code 4522 on the House Bill 554. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt. We're now on House Bill 554 as amended. Any questions for the sponsor? Question has been called. Any objection? Seeing none, we're now voting to send House Bill 554 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on.
Thank you, Mr. Chairman and committee.
You don't have any more in here today? Oh, okay. Maybe next week. Well, thank you. Item number 15, House Bill 722 by Chairman Hulsey. You recognize there's an amendment code 4142.
That's correct. That's
All right, you are recognized on the amendment.
Thank you, Mr. Chairman. This amendment makes the bill. Last year, I ran this same bill. It passed, but it didn't get funded. And so I'm hoping for a different outcome this time. And it doesn't change anything from what you had last year. Voluntary manslaughter is a Class C felony. Lots of times you get to a voluntary manslaughter charge when somebody's been charged with first or second degree murder, and a jury can reduce it down to voluntary manslaughter, but it's illegal to tell a jury what the sentence is. So Class C is 3 to 6 years, and they get horrified, and so does the family when somebody kills somebody. And they get 3 to 6 years or are eligible for parole before they get through the court system and found guilty. The difference is if an aggravated assault is a Class C felony. If I pointed a gun at you, and not at you, at anybody, and threatened you, that's a Class C felony, aggravated assault. Under voluntary manslaughter, if provoked, and I don't just point a gun at you, but I shoot you and kill you, and I'm charged then with voluntary manslaughter, it's the same Class C felony. So what this bill does is it bumps voluntary manslaughter to a Class B, which is 8 to 12 years. But with that, I renew my motion.
Well, very good. We are on the amendment. And the amendment makes the bill?
It does.
All right. Any questions? Questions been called on the amendment. Any objections? Seeing none. Now voting to adopt Amendment Code 4142 on the House Bill 722. All those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're on House Bill 722 as amended. Any questions for the sponsor? Question's been called. Any objections? Seeing none, we're voting to send House Bill 722 as amended to full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Members, are there anything else that needs to be discussed before we call it quits for today? We've reached the end of our calendar. I want to commend you on your work today. I appreciate each and every one of you. I know that going forward, we're going to see a lot more bills on the calendar, so encourage you to keep working hard and study diligently. If I don't have any other thing else, we are adjourned.